us. This is the event on the 19th Amendment Centennial and the battle for the Equal Rights Amendment. I am Jeannie Suk Gersen, and I will be introducing and moderating this event, which has been organized by the American Marshall Scholars. The AMS is a 501c3 nonprofit organization with roughly 2,000 Marshall Scholar members. It is dedicated to strengthening the friendship between the United Kingdom and the United States through investing in public programs, exchanges, and the Marshall Scholarship, a program that has helped strengthen international understanding and advancement in nearly every field of human endeavor. We would like to thank our friends at James Madison's Montpelier for partnering with us on this event. This event is the latest installment of the Marshall Arts and Humanities series. Please join us for the series' next installment on August 7th at noon Eastern for a conversation with Patrick Radden Keefe, the writer and host of Winds of Change, an 8-part podcast series from Pineapple Street Studios, Crooked Media, and Spotify, which investigates the strange convergence of espionage and pop music during the Cold War. So I think now we are going to hear from Eugene Hickok, who is the chairman of the board of the Montpelier Foundation.
Hello, everyone. I am Eugene Hickok. I chair the board of the Montpelier Foundation. As I hope you know, Montpelier is the lifelong home of James Madison, commonly referred to as the father of the Constitution and one of the primary architects of the Bill of Rights. When you come to Montpelier, you can visit the very room where Madison sat, looking to the west, thinking of all the opportunity this country possessed, and wrote, in essence, the rough draft of the Constitution, the Virginia Plan. It is also the home of a very large enslaved community. And at Montpelier, we have an exhibit called The Mere Distinction of Color that talks about those issues and the permanent challenge those issues present today. Montpelier is a wonderful place: gardens, architecture, and the home of the Center for the Constitution. So I hope you'll visit. We're very pleased to be sponsoring this with the Association of Marshall Scholars. And during the crisis we currently confront over Corona, a lot of people aren't coming to Montpelier. So we decided, well, it's a place to visit, it's also a place that wants to visit you. And that's what's happening today. I wish you a good conversation. Thank you.
Hi, I am back to introduce the speakers today. So first, there's Julie Suk. She's a Marshall Scholar, the class of 1997. She is the author of the book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment. She's a professor of Sociology, Political Science, and Liberal Studies at the Graduate Center at the City University of New York, where she also serves as the academic dean overseeing the Graduate Center's interdisciplinary master's programs. She's an expert on comparative constitutional law, equality and anti-discrimination law, and procedure. She will be a visiting professor of law at Yale Law School in the fall of 2020. She's a frequent commentator in the media on legal issues affecting women, including in publications such as the New York Times, the Washington Post, and CBS News. Her book, We the Women, is coming out this August, which is the centennial month of the 19th Amendment, and it is now available to pre-order on Amazon. Speaking with her will be Kathleen Sullivan, who is a Marshall Scholar of the class of 1976. She is a partner in Quinn Emanuel's New York and Los Angeles offices. She's the chair of the National Appellate Practice of that firm. She's the former dean of Stanford Law School. She joined the firm in 2005 after a long and storied career as a professor at Harvard and Stanford Law Schools, where she taught constitutional law to several generations of law students. I teach from her renowned casebook. In her appeals practice, she also does an active practice in the trial practice of the firm, and she has done very significant pre-trial, trial, and post-trial practice in federal district courts. And for all of this, she has been named to the Legal 500 2017 Hall of Fame, which highlights lawyers who are repeatedly recognized by the publication. So we are going to begin this event with Julie. If you have questions for Julie, please direct them to the Q&A function on the bottom of your screen. So we will start with Julie opening the program with a discussion of her book, followed by a conversation between her and Kathleen Sullivan. And there will be a time to address questions you have at the end of the program. Thank you.
So thank you so much. Thank you to the Association of Marshall Scholars, the CUNY Graduate Center Sociology Program, my current intellectual home, who's also provided support for this program, and James Madison's Montpelier for generously hosting this event together. All three of these institutions are very special to me and have contributed in important ways to the genesis of the book that we will discuss today. The Marshall Scholarship allowed me to finish out the 20th century at Oxford, studying political philosophy on the Marshall Scholarship, nourishing my passion for the idea of equality, and the Graduate Center Sociology Department, where I am now, really deepened my understanding of inequality. And finally, James Madison's Montpelier, the Robert Smith Center on the Constitution, is really the place where this book was born. The Comparative Constitutional Law Roundtable provided the first audience for my scholarship about the Equal Rights Amendment. And today, I'm really happy to welcome the high school educators who are participants in Montpelier's 19th Amendment Centennial Seminar, which I'm teaching, who are joining us today in this event. At Montpelier, as Jean mentioned, here in Virginia, well, virtually in Virginia for us, James Madison wrote drafts that became the US Constitution, designing political institutions for a society of equals, even though our institutions did not regard women as full participants at the time, and the economic order was sustained by the unequal institution of slavery. Over 200 years after that Constitution was ratified, Virginia became the 38th state to ratify the Equal Rights Amendment to the US Constitution in January of this year, 2020, the year in which we celebrate the centennial of the constitutional amendment that guaranteed women the right to vote. Under our Constitution today, 38 is the number of states needed to ratify a constitutional amendment, but whether the ERA is part of the Constitution is actually a matter that is currently contested because the proposed ERA had a deadline for ratification that elapsed about 40 years ago. My book, We the Women, was written so that I could learn about the women who fought across generations for their constitutional inclusion as equals. And I wondered, as I wrote the book, why this goal has taken so long. Of course, constitutions by their very nature are intended to go on for a long time. They're intended to outlive their founders and their framers. And because they propel the polity into the future, they're also intended to change and adapt to that future. The US Constitution begins with the famous words, "We the people of the United States," in order to form a more perfect union. That preamble ends by referring to the importance of securing the blessings of liberty to ourselves and our posterity, the future, our posterity. Our Constitution envisions a process of making this nation more perfect as it gets inhabited by our posterity. At the same time, the rights of women, without whom our posterity could not possibly be birthed or raised, were not guaranteed or even assumed at the founding. So that's where the Equal Rights Amendment has come in. The Equal Rights Amendment was first proposed in 1923, shortly after the 19th Amendment granting women the right to vote was ratified. The ERA provides that equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And there are additional provisions in the amendment that would give Congress the power to enforce the provisions of equal rights, and providing that the amendment would take effect 2 years after the date of ratification. Now, even though that amendment was introduced in Congress in 1923, it took almost 50 years for Congress to adopt it. It was adopted in 1972. And it was only this year, January 2020, after almost another 50 years, that Virginia became the 38th state to ratify the amendment, albeit after the original deadline. And now we're asking, is the ERA part of the Constitution? And should it be after all of these years? And there's also a very interesting and important question as to what the ERA would mean, both legally and politically, as an amendment that was made across generations. So We the Women traces the line of women lawmakers and lawyers who waged this cross-generational battle for the ERA. By thinking about these women as founding mothers, the ERA gives us the opportunity to make official the contribution of women to our constitutional democracy. Unlike our founding fathers, the status of the women who made constitutional equality, the status of these women as constitution makers will remain invisible and ambiguous unless and until the ERA is fully legitimized. And so that was one of the projects of this book. I wanted to narrate the long story of how the ERA was made and what its founders and framers' goals were and are for a general reader and citizen, as well as for lawmakers, lawyers, and judges who will eventually enforce the ERA once it is legitimized and added to the Constitution. I want to leave as much time as possible for conversation about some of the issues with Kathleen. I'm so honored that Kathleen is able to join in this conversation. And so before we begin the conversation, though, I just wanted to highlight at least some of the forgotten mothers of the Constitution, if you will, who are featured in the book. Some of the characters, the women who played an important role in making constitutional equality for women. So among the instigators of the Equal Rights Amendment was Crystal Eastman. Crystal Eastman was one of the first women to graduate at the top of her class at NYU Law School. So she was a woman lawyer who advocated and in fact helped draft the Equal Rights Amendment in the early 1920s. And she was interested in generally guaranteeing equality for women, largely because she was very attuned to the inequalities women faced because they were mothers, and particularly inequalities women faced in the workplace and in industry. Then in the 1940s, we saw women like Mary Church Terrell, an African-American woman who really globalized the ERA. She engaged women in constitutions around the world through her involvement in the women's peace movement, and she testified in favor of the ERA as a representative of the National Association of Colored Women to bring attention to the ERA as participating in the global movement for human rights and equal rights for women as an international constitutional norm. And then finally, I want to draw attention to the women in recent memory who basically resurrected the ERA after it had been assumed dead for so long. State legislators, and many of these women in state legislatures who are women of color, who are particularly interested in the ways that inequality manifests itself in the 21st century through the persistence of sexual harassment, unequal pay, unfairness against pregnant mothers in the workplace. So women like Pat Spearman in the Nevada Senate, who really resurrected the movement for the ERA by having Nevada ratify in 2017. In Illinois, on the heels of the Me Too movement, there was a long discussion of what the government should do about the persistence of sexual harassment and the forms of the casting couch in government and in the Illinois state legislature even. Amidst that conversation, women in the Illinois state legislature, like Heather Steens, Barbara Flynn Curry, Juliana Stratton, led the drive to achieve Illinois' ratification in 2018. And then, of course, very importantly, Virginia, Jennifer McClellan and Jennifer Carroll Foy, two African-American women who are in the Virginia legislature, both of whom today happen to be running for governor of Virginia. They sponsored the ERA resolution and brought attention to issues facing inequalities faced by working women because they are mothers. And then finally in Congress, there's a move to lift the deadline on the ERA, to make it clear that the ERA can still be added to the Constitution. And there are women in Congress, including Sheila Jackson Lee and Pramila Jayapal, who've been on the House Judiciary Committee, bringing attention to 21st century issues, the ways in which the ERA can solve certain imbalances of power facing women. And Pramila Jayapal talking about the importance of the ERA as a response to inequalities faced by parents and mothers in the workplace, calling the ERA a vote for families. And then women like Rashida Tlaib, who on the floor of the House, as they voted to remove the deadline earlier this year, drawing attention to the ERA being broader than perhaps was imagined in the 1970s, focusing specifically on problems facing women of color, immigrant women, and trans women. These women advocated for the ERA to make the union more perfect, and in so doing, they were themselves the change that they were fighting for. And so I want to end on the note by saying that the ERA is important now, not just because it might change the law. That is, since 1972, the law that we have under the existing Constitution, under the Equal Protection Clause, it already has begun to undo gender discrimination since the 1970s. The ERA would actually finish that project, not only as a legal matter by reaching forms of sex discrimination that the Supreme Court has refused to include in its equal protection jurisprudence, things like pregnancy discrimination that the Supreme Court in its equal protection jurisprudence has not recognized as an equal protection problem. So there are some legal things that the ERA can achieve. But I want to suggest that what we can really learn from 100 years of women as constitution makers in their struggle for the ERA is that this legal fine-tuning of the Constitution is not only what this amendment is about. This amendment is about recognizing the status of women and their contributions to American democracy as constitution makers, and making the ERA law, making it official that women have already changed the Equal Protection Clause since the 1970s and changed the Constitution in a manner that's permanent and lasting.
Well, thank you, Julie. This is Kathleen Sullivan, and it's my honor to be here with you, my fellow Marshall Scholar. I think both of us can say that having the Marshall Scholarship and being able to study in Britain was formative for our career, including our careers in constitutional law, and gave us some insight into the origins of our own system of rights and some comparative constitutional observations. And I thought we could start there. You made a very interesting reference to the role of other constitutions and international human rights norms in some of the work of the unstoppable mothers behind the ERA. And I wonder if we could start with that comparative observation. It's striking that we are the only nation among all of the advanced industrial democracies with a written constitution that does not have an equal rights protection in the Constitution. That's every constitution drafted after World War II and the new constitutions we saw at the end of the 70s and the 80s, South African Constitution, the Constitution of the newly liberated former Soviet Socialist republics, and classically all the old European democracies, they all protect the rights of women to be equal to men in their constitutions. We do not. The 19th Amendment, whose centenary we celebrate this month, is the only part of our Constitution that refers to a protection against gender discrimination, and yet that is exclusively limited to the right to vote. So could you talk a little bit about the role of international norms and comparison to other nations in the work of the mothers of the ERA?
Absolutely. Thank you so much, Kathleen, for bringing attention to that issue. And I want to flag that when you, Kathleen, testified before Congress last year on removing the ERA deadline, you noted that it is a national embarrassment for the United States that we do not have a provision guaranteeing equal rights for women and men or prohibiting discrimination on grounds of sex. The United States is certainly an outlier, and I think that is largely because we have one of the oldest constitutions. Most of the constitutions that you reference were written in the 20th century or the 21st century when it was very obvious that a provision on sex equality was a staple of constitutionalism. And many of the constitutions that were adopted after World War I and certainly after World War II have these provisions on equal rights between women and men. And more interestingly, in the late 1990s and the early 2000s, some of those countries amended their constitutions again. France, Germany, and Italy amended their constitutions in the 90s and the early 2000s to make clear that the equal rights between women and men goes beyond formal equality and authorizes affirmative measures to promote gender equality. And some of these developments you see in other constitutional traditions because they are actually easier to amend than the US Constitution. The US Constitution is notoriously difficult to amend because Article 5 of the Constitution requires 2/3 of both houses of Congress, as well as ratification by 3/4 of the states. But I do think that it's an important part of the ERA's development over 100 years, that when you see, it didn't really get off the ground when it was first introduced in the 20s. And when you see some movement, it's really after World War II. After World War II, the congressional testimony is full of references to the UN Charter, which explicitly references equal rights between women and men. And people like Mary Church Terrell, on behalf of the National Association of Colored Women, point to Japan's constitution, which at that moment has a women's equality provision, which our constitution does not. And it's really after those hearings, after World War II, that you get the first vote in the Senate to pass the ERA. In 1950 and 1953. It didn't make it through the House in that decade, so we had to wait until the 1970s before both houses adopted the ERA. But I think there has been a strong influence of international norms and foreign constitutions in the slow development that we see in favor of the ERA.
It's so striking because it's usually our constitution that influences other constitutions and not other constitutions that influence ours. So thank you very much for that. I just want to remind all our audience here, and again, thank you so much for being with us today, that you can direct questions to Julie through the question and answer function at the bottom of your screen, and we'll start addressing audience questions in about 10 minutes when we finish our dialogue. And I wanted to turn next, if I could, to Julie, your fascinating subtitle, We the Women, great title, and we, the Unstoppable Mothers of the ERA. And it seems to have it's a bit of a double meaning there. You refer to the mothers of the ERA in the same way as we refer to the fathers of the Constitution. And yet you also suggested in your wonderful opening remarks that motherhood is a key issue in what the ERA might mean, both for the progress of women and for those who say, well, women and men are different. Men cannot gestate and bear children. So can you talk a little bit about your title and what you mean by the mothers of the ERA and what the ERA means for mothers?
Thank you so much, of course. So substantively, I really focus on who you might call the founding mothers of our Constitution, assuming the ERA does eventually get legitimized. So the founding mothers are those who fought for women's equality, because if we get an equality amendment, those are the framers, those are the founders. And I think it's important to think of women in constitution making as the equals of the founding fathers. And I'm really focusing in the book on women in Congress and women in state legislatures who were always small in number, but huge in political persistence over time, therefore unstoppable. over time. And of course, the fact that they're small in number in these legislatures, but huge in political persistence over time matters, because the reason women are so underrepresented, really from 1776 or from the very beginning until now, the reason women are so underrepresented is because they are mothers. So we have equal protection law from the not just equal protection, 14th Amendment law from the late 19th century in cases like Bradwell versus Illinois, that say women can't be lawyers, or a state can exclude women from the legal profession because the province of women is the home. And so it's really women's association with motherhood and the home, childbearing and child-rearing, that over time was a justification for unequal rights and women's exclusion. And that exclusion, even though it's been overcome in some ways by equal protection law with regard to sex equality, as it's developed, it's an unfinished project, largely because there are still many inequalities that women face because they are mothers. And the hope is that having new legal developments like the ERA will be able to finish the project of addressing those inequalities, even though the problem is not a new one. It's been around for a very long time.
Yes, thank you for that. We may mention that the ERA actually has a section 2, which allows Congress to pass legislation to enforce the amendment. And it may be that some of the ideas you just expressed about helping increase equality of women and men in some domains of our commercial lives, like equal pay, is going to be reinforced not just through judicial enforcement of the ERA, but through congressional enforcement of the ERA. So you mentioned that the Equal Protection Clause has already been interpreted to provide a measure of sex equality. And of course, anyone who has followed recent biographies of the notorious RBG, our great Justice Ruth Bader Ginsburg, knows that when she was a young lawyer, she did a great deal just personally to bring about the decisions that interpreted the 14th Amendment Equal Protection Clause to provide a measure of equality to women. Could you talk a little bit about why do we need the ERA if we have these interpretations of the 14th Amendment Equal Protection Clause to extend some protection to women against sex discrimination?
Yes, absolutely. So I have two responses to that question that I think both are about Ruth Bader Ginsburg in many respects. So first, the cases in which that moved the Supreme Court to recognize sex equality as a constitutional principle under the 5th and 14th Amendments, the Equal Protection Clause, those cases were decided starting about 1971, Reed versus Reed, Frontiero versus Richardson, and Ruth Bader Ginsburg wrote briefs in those cases. And what's very interesting about those cases is that the timing is really not a coincidence. Those cases are being decided by a Supreme Court that's very aware of the process that Congress is engaged in proposing the Equal Rights Amendment to the states. And in Frontiero, the justices even mention that Congress has voted by well over 2/3 majority for the ERA. So arguably there's an influence where the movement for the ERA is actually having a causal effect on the equal protection jurisprudence that we get. And I think that putting the ERA formally into the Constitution now would give credit where credit is due and recognize that genealogy, and that's important. But secondly, one thing that Ruth Bader Ginsburg was involved in at the same time that she was doing Reed versus Reed and Frontiero and some of those early sex discrimination cases from the 70s was a case called Struck versus Secretary of Defense. And that involved a woman who was basically discharged from the military because she was pregnant. And she was told that if she wanted to keep her job, she should just have an abortion. And Ginsburg was involved in the argument, in developing the argument that that was sex discrimination. Sex discrimination against mothers-to-be was sex discrimination. It wasn't just pregnancy discrimination. Pregnancy discrimination was a form of sex discrimination. And that case was eventually dismissed as moot because the military decided to give her back her job after all. So it never actually made it to the Supreme Court, and we didn't get a landmark decision about pregnancy discrimination until later. And later, when the Supreme Court actually considered the question of pregnancy discrimination, it was in a disability benefits case, and the Supreme Court said that pregnancy discrimination was not sex discrimination in a case called Godaldick versus ALO. And so the goals of gender equality were not necessarily finished because the Supreme Court recognized sex discrimination in some realms, but not in others. And so the ERA would first of all recognize the progress that we've made so far, but also push the Constitution to go farther to address inequalities that remain.
So last question before we go to the wonderful audience questions that are rolling in right before my eyes, and you can address those to the Q&A function down at the bottom of your screen. Last question is, what will the ERA be interpreted to mean? We saw the Supreme Court just a few weeks ago interpreted Title VII, which bars sex discrimination in employment, was interpreted by the Supreme Court, to some people's surprise, to also bar discrimination on the basis of sexual orientation or gender identity in the workplace. Will the prohibition on sex discrimination in the Constitution similarly be read to protect gay people and transgender people?
So I hope so. I certainly think that the words in the ERA on account of sex, similarly to the words in Title VII because of sex, could easily and compellingly be interpreted in an expansive way to include discrimination on the basis of sexual orientation and gender identity. I agree with that interpretation, but I also recognize that that is not the only reasonable textual interpretation of those words. I think the ERA should be interpreted to prohibit these forms of discrimination, but I don't think that the text is going to get us there alone. I think that the reason discrimination because of sex includes discrimination because of sexual orientation and gender identity has a lot to do with the meaning, the social meaning and the social context of sex and gender relations in the 21st century, which are different from perhaps what they were earlier on. And so that's why I think right now there's an importance to legislative history being made on the floor of state legislatures as they ratified the ERA in 2020 and Congress removing the deadline also in 2020. Because to my mind, it's not simply the words on account of sex that get us to sexual orientation and gender identity. It's not textual inference alone, but because of things like state legislator in Virginia, Danica Roem, the first transgender woman ever elected to the Virginia General Assembly, standing up during ERA ratification floor debates and saying that today, on account of sex, actually means on account of sexual orientation and gender identity as well. And I think those statements, not only in Virginia, but in the other states that have ratified in the 21st century, amplify the types of meanings that that the ERA should take on as it gets legitimized moving forward.
Well, that reference to what happened on the floor of the Virginia legislature this year when they ratified and became the 38th state to ratify the ERA takes us to our first audience question from Jenny Davis, thanking you from Indiana. Jenny asks, I don't fully understand the current status of the ERA. Since it achieved the 38th state ratification after the deadline, what does that mean? What is next?
So I think you're not the only one who's asking that question. That is a very important question that's being asked, and by many actors, including people who are bringing lawsuits. The state of Virginia is actually bringing a lawsuit to get some of those questions answered. So we're in unprecedented constitutional territory here because this really is the first time that we've had an amendment that is being, that states have continued to ratify after a deadline that Congress expressed when it sent the amendment to the states for ratification. And the deadline was interesting in the ERA because in previous constitutional amendments, first of all, for most of the US Constitution's history, there were no deadlines on ratifications. And Congress started doing it with the Prohibition Amendment when it voted on the Prohibition Amendment in 1917. So they started putting these 7-year deadlines into constitutional amendments, and it became a fairly common part of constitutional practice in the 20th century. But when Congress started doing it, those deadlines were put into the text of the amendment itself. In the ERA, it was done very differently. With the ERA, it was put in a resolution that Congress passed and not in the text of the ERA itself. So there's a dispute as to what the legal effect of that kind of deadline is. Is it a deadline that Congress can later change or remove, right? Congress did actually change the ERA deadline once in 1978. They extended it by a few years, and there was a debate at that time as to whether or not that was legitimate. And one House of Congress has now voted to just be absolutely clear, lift the deadline. There was a majority vote in the House this year to lift the deadline. But I think there's a lot of disagreement, as to whether or not the deadline has any legal effect. If it doesn't, then the ERA is part of the Constitution now. If it's possible that the deadline has some effect, there's a question as to what effect it has, right? The deadline on prohibition was not only in the text of the Prohibition Amendment, it actually said this amendment shall be inoperative unless ratified. And that's what we might call an exploding deadline. Congress made it really clear. If it's not ratified in 7 years, it's dead, dead, dead. The ERA deadline just says this amendment shall be valid when ratified in 7 years. And that doesn't necessarily read like an exploding deadline or an exploding offer, right? It really reads more like it'll definitely be an amendment if ratified, when ratified in 7 years. If not, then who knows? We'll see. Right? And there are also questions now as to whether Congress should decide or whether the courts should decide. And I think those are some of the questions that are being raised in the litigation.
So the short answer to Jenny is that it's being litigated in the courts, it's being debated in Congress, and deadlines may or may not operate. There's no requirement in Article 5 that an amendment be adopted in any given time period. And we should note that the 27th Amendment to the Constitution, our latest ratified amendment, was ratified 200 years after it was promulgated. So, it was promulgated by the first Congress, proposed by the first Congress, and then ratified in the 1990s. So there's no requirement in the Constitution that you ratify an amendment within any particular time period. What's being litigated now and debated in Congress is whether, if Congress imposes a deadline, what force does that have? So we'll have to stay tuned on that. But since you took us back to 1978 and 79 and the extension to 1982, it takes us to our next question from Sewell Chan. The Hulu series Mrs. America has given new attention to the ERA and its opponents, notably Phyllis Schlafly. Have you had a chance to see it? We both have. Yes, we've talked about it. And if so, what impact might it have on present-day attempts to revive and adopt the amendment? So, of course, it's a kind of feminist tragedy. Cate Blanchett playing Phyllis Schlafly brilliantly shows that the woman who led efforts to stop the ratification of the ERA was herself a phenomenally talented lawyer and activist who was thwarted by a lot of the sexual stereotypes the ERA is designed to displace. And so that's the series. Do you think the series will have any effect on current political debates? And was it true to history as you watched it?
So thank you, Sewell. Hi, Sewell. Thank you so much for that question. So yes, I did watch it and really enjoyed watching it. And it's always hard to predict what the effect of culture is. What I will say is that there's a very important story that Mrs. America tells. And I think it's a story that is familiar about the ERA, which is that the reason it died was that women couldn't agree as to whether they really wanted equal rights. And there was also some confusion about what the ERA would actually do, right? And that's a real focus of the show. And to some degree, it's true. That is, the Stop ERA movement that Phyllis Schlafly led in a battleground state like Illinois. Illinois is a state that did not ratify during the deadline period in the 1970s, but later ratified in 2018. In those battleground states, the story we often tell is that women couldn't agree whether or not they really wanted an ERA. And on the one hand, part of that story has to do with the ERA's effects on housewives and mothers, right? Phyllis Schlafly convinced a lot of women that the ERA would actually be bad for mothers. And I think that was actually not true. And if you look at some of the unstoppable mothers of the ERA, some of the women who are portrayed in the show, like Shirley Chisholm. Shirley Chisholm was very concerned with inequalities faced by women because they are mothers and the lack of childcare and the lack of publicly supported childcare. She was in fact herself a daycare center director before she was elected, first to the New York State Legislature and then to Congress. And she was at the same time working on legislation on the Comprehensive Child Development Act. And there were many debates. Women like Margaret Heckler in floor debates about the ERA really emphasized the difficulties faced by working mothers and single mothers. And so this notion that the ERA was actually going to be terrible for mothers was something that Phyllis Schlafly proliferated. And I don't know that, in my view, the show could have done more to show the engagement of women in Congress during that period on issues surrounding motherhood and caregiving. And even someone like Patsy Mink, the first woman of color ever elected to Congress, an Asian American woman from Hawaii, really, she led efforts on Title IX and also really talked a lot about the early Title VII cases involving the rights of working mothers. That was also a very important part of the ERA's legislative history that I think doesn't get enough attention in that show. And then finally, one thing I will say, and this is something I try to pay some attention to in the book as I look at the history of failed ratification in places like Illinois and Virginia in the 1970s. Part of the story is the division among women about the ERA, but another part of the story is just parliamentary power and politics. The reason the ERA doesn't get ratified in Illinois is not only because Phyllis Schlafly is giving bread to male legislatures when the votes are happening. It's also structural. In Illinois, you can't ratify a federal constitutional amendment unless you have a 60% supermajority. That kind of rule is not very common. In most other states, a majority will do it. But in Illinois, you needed 60%. And so there were actually several votes throughout the 1970s and the early 80s in which the majority of the Illinois legislature voted to ratify the ERA, but that didn't meet the 60% threshold that the legislature imposed on the ratification of federal constitutional amendments. And I think if you have a supermajority rule like that, having a figure like Phyllis Schlafly proliferating some myths and doubt actually goes a long way in defeating an amendment. And I think those dynamics we need to pay a little bit more attention to rather than just the cultural story about women and mothers disagreeing about the ERA.
So unfortunately, we're only going to have time for 2 more questions. So I'm going to take a number of the wonderful questions that have come in and combine questions that ask in various forms, what will the ERA mean for LGBTQ people, for gender nonconforming people or gender non-binary people, for trans people? And forgive me, questioners, for combining your questions, but do you want to comment briefly on that in light of Bostock?
Yes, absolutely. So I think it's important that when the House Judiciary Committee reported out the deadline removal bill earlier this year, it explicitly said in its report that eventually led to a favorable vote in the House that they understood on account of sex in the ERA to include on account of sexual orientation and gender identity, that it could be and should be interpreted that way. And I think that piece of legislative history is important. And I think remarks like the one I referenced by Danica Rome in the Virginia legislature are also important in really strengthening the view that the ERA ban on sex discrimination, completing ratification in the 21st century has this broader meaning, broader than what the framers might have envisioned in the 1970s.
And for our final question, I'm going to select the wonderful question from Sarah T., who asks, are you optimistic about the eventual passage of the ERA, and what can we, the people, do to help?
So I think that to the extent that we're in a moment now where 38 states have ratified. I saw a recent study by the Pew Research that suggests that 78% of the American public favors the addition of the Equal Rights Amendment to the US Constitution, and one House of Congress has voted to lift the deadline. There's a bipartisan bill in the Senate also to lift the deadline, and that has 48 sponsors, and it's an election year. So, and I will say that as a historical matter, in Virginia, they ratified the ERA in 2020. They had been trying for a while. They did have the votes in the House of Delegates to ratify, but it was stuck in committee for a long time. And then finally, the proponents of the ERA just made it a real election issue in 2019. Many of the people who won their elections, including Danica Rome, explicitly referenced ERA ratification in their election campaigns. So I think a lot of this is a political project, and I think those who favor the ERA should pay attention to the ERA as an issue with regard to the composition of the Congress in the years to come.
Well, thank you so much, Julie, and that's a wonderfully hopeful and optimistic ending. And thank you for a wonderful discussion of your book. We want to remind everybody that this exciting book, the absolutely riveting stories of the people that Julie has described here, is available. You can look at the chat function to find We the Women, the Unstoppable Mothers of the ERA. So look to your chat function to see where you can buy the book. And thank you all for coming.
Thank you, Kathleen. It's been a pleasure.
It's been a great pleasure. Thank you.